Mr. Whitmore, I'll give you the floor. What's your thoughts as far as the child support is concerned?
Um, I have no issue providing support to my children financially. However, the amount of 1,035 would cause undue hardship on myself um, uh, due to the amount of debt that I have and the amount of income that I have. Also, I would like to have my physical parenting time returned back to my 3 days a week that I had previously. It was dropped to 1 day after a financial dispute. I was scrambling together to give her 7.
Today we are going to step inside a courtroom where frustration, finances, and fatherhood collide. The opening moments set the tone as Mr. Whitmore explains he is not refusing child support, but drowning under it. He lays out debt, reduced parenting time, and the emotional cost on both himself and his children. This is not a man denying responsibility, but one asking the court to see the full picture. Right away, the tension is clear. Money, access to children, and pride are all tangled together, and the judge is listening carefully as the stakes are established.
$100 a month. And I was only able to give her $600 a month 1 month after I had to borrow from her credit card and borrow from these different components to get her the money. And she decided that I not only owed her that money, but I owed her a $50 late fee on top of that. After that, she decided to change the schedule to 1 day per week. I didn't want to fight with her. I wanted to have my day in court to discuss that. But the 52 nights over week has hurt me emotionally, my children emotionally. X has mentioned to me that he does miss spending as much time as we had together. So I offered more parenting time because that's what I can offer. I cannot offer more financially than I was. I have about $6,000 in monthly debt and income of about 3,500. So every month I have to get creative on how to cover the bills. That including her is one of those bills. Even when we had equal parenting time, when I had the children Tuesday, Thursday, Saturday, and half of Sunday, I was still paying her $700 on top of me having the kids equal time. I help provide a phone for her. I provide a phone for the children. I helped her when she initially moved out with a car with vehicle insurance. I helped her sign her lease on her home when she first moved in. So I've done everything I could to be a good model father, to take care of my children. I have been villainized in this whole process, but I am doing everything I can to be a father. I didn't
To watch the argument deepen as Mr. Whitmore shifts from numbers to narrative. He lists expenses, memberships, insurance, and the everyday costs of raising children, all while stressing how limited parenting time has blocked his ability to earn more. This section feels like a balancing act between logic and emotion. He wants the court to understand that support is not just a payment, but time, presence, and effort. The pressure builds as he argues that the current arrangement hurts both his finances and his bond with his kids.
have a father growing up, so I wanted to make sure I'm in my children's life at present. So I do everything I can with my children over the summer. We take them to YMCA, so I pay a $46 a month YMCA membership. I take them to Chuck E. Cheese, which is a $12 a month membership. I pay their phone bill, which is $80 a month. And then the insurance, it's $200 for just me, but adding the 2 additional children is additional $200 as well. So I'm not sure where the calculation is. And then on top of that, she's limited now that she's limited from Tuesday, Thursday to only Saturday. Only having the children on Saturdays, hindered me from making any additional income as well. Operating a business or anything, a side hustle, because Saturday is a primary day for that. So I've been hurt by this whole process. Yeah.
Well, first of all, I don't know who's villainized you because I certainly haven't, and I'm pretty sure Ms. Rummelt hasn't as well. Let me first of all tell you, insofar as the parenting time is concerned, you have a couple of different options. Right now, you have nothing on paper. And verbal agreements, as I always say, are not worth the paper they're printed on. If you have a verbal agreement, people can duck and dive and not comply, those types of things. So there's a couple of options you have. One, you can ask the friend of the court to conduct what's called facilitative parenting time. That's where they'll sit down with you and sit down with the other side and try and hammer out a schedule and put it on paper what the parties have thus far been elusive in getting out as far as some written schedule. Your position as far as the child support's a little bit more problematic. The child support guidelines in Michigan are what's called both presumptive and mandatory, meaning that they have to be followed and that the guidelines are presumed.
Today we are going to see the courtroom pivot from emotion to procedure. The judge responds firmly, clarifying that no one has villainized him and explaining why verbal agreements hold no weight. This is where reality hits hard. Parenting time can be negotiated, but only through formal channels. Child support, however, is bound by strict guidelines. The judge carefully explains that most personal bills simply do not matter under the law. It's a sobering moment where personal hardship meets an unbending system.
To be correct, there's always issues when it comes to this. Bills are an extremely important calculation in everybody's mind, everybody, to and including mine. Problem is the guidelines are more prejudicial when it comes to bills. There's only certain bills you can get credit for and deduct. So what you can do is if this amount is, if you wish me to take a look at child support and take a look at parenting time, what you would have to do is file a motion for both of those with me. I'm here every other Friday, most of the time, and I would be happy to entertain whatever thoughts you have as far as child support. In fact, I may even send it back to the friend of the court for another recommendation to me. But the fact is, I'm looking at this, the actual incomes were used for both parties.
Today we are going to hear the judge outline the only real path forward. Motions must be filed, evidence must be prepared, and patience is required. The court offers structure, not sympathy. The judge explains how and when these issues can be reviewed and even suggests sending matters back for further recommendations. This part carries quiet tension. There's hope, but only if the rules are followed precisely. The message is clear. The court will listen, but only on its terms.
And the income is strictly based, the guidelines are strictly based on the income, and certain things you can deduct. Most bills are not it. So what I would tell you to do is, after today, is you can file a motion with me for specific parenting time and a review of your child support. Those are held every other Friday at this time, and I would be happy to listen to whatever you have. You can submit to me whatever you have as well, give you more time to somewhat prepare for it, and we'll cover those in that fashion. That's what I can tell you. Okay.
Okay, and what are the name of the motion? Is it motion for child support and motion for parenting time?
Correct.
Okay, thank you.
And if you're choosing to represent yourself, the Legal Assistance Center on the 5th floor has all these forms that you can stop down and utilize. They're not attorneys there, but they do an excellent job of pointing people in the right direction. And I'm a big fan of the Legal Assistance Center. So if you're going to represent yourself, that's probably the first place that I would go. They're on the 5th floor of the courthouse. Okay.
Your Honor.
I really don't need that, Ms. Harmston. I'm going to enter this subject to those things. I know you probably have a lot of response to what he has said, and it's not that it's not important. It's just that I'm telling him to, in essence, save it for a motion, and I'm going to tell you the same thing too. When he files a motion, he's got to let you know in time, 9 days if by mail, 7 days if 9 days by mail, 7 days if hand delivered, and we'll cover all of that at that time. I promise I'll listen to every word you say. Okay.
Understand. My questions are more in regard to child support right now. The court should probably know that he has no overnight visits as of now. And I'm wondering about back pay. And
Yeah.
I'm also wondering who is responsible for the deductible on my children's insurance. Our son has surgery Monday. And
I'm going to stop you there, Ms. Harmson. These are questions that I cannot answer for you.
Okay.
You would definitely need to seek out legal advice. The effect date per the request by the prosecutor's office is 10/1, I believe. So it's back that far, and that's in accordance with the law. But if you think I should take a look further back, you can put that in your answer to Mr. Whitmore's motion. Okay.
I was told that I could file up to like 3 months of back pay, just because Mr. Whitmore only paid in August $350.
Yeah, I can't answer that for you today, Ms. Harmson. I'd be happy to answer it at a standalone motion.
Okay.
I'll answer all those questions for you, I promise. Okay. Ms. Rummelt, anything from your end?
No, Your Honor, I will just make the correction on the effective date. And again, I apologize.
That's fine. Thank you. And you submit that via DocuSign. Folks, I know you and I are probably going to see each other again. I wish you the best, and you can both sign off or adjourn. Thank you.
Today we are going to witness the final stretch where unresolved questions hang in the air. The mother attempts to raise concerns about back pay, overnights, and medical costs, but the judge stops her, reinforcing that none of this can be decided today. Everything must wait for proper motions. The hearing closes without resolution, only direction. Both sides leave knowing this fight is far from over. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.